Good morning. I'm Gary DeWaal, and this is Bridging the Week for February 10th to 14th, and today is February 17th, 2020. The International Organization of Securities Commissions articulated considerations for worldwide regulators evaluating crypto asset trading platforms within their regulatory perimeter. These platforms are commonly known as CTPs. However, IOSCO noted that this assessment poses unique issues because while CTPs share many common characteristics of trading platforms, they also perform functions associated with intermediaries, custodians, transfer agents, and/or clearinghouses. Separately, two food giants and the Commodity Futures Trading Commission appeared poised once again to resolve the CFTC's 2015 enforcement action charging manipulation against the defendants. A prior settlement was set aside by the presiding judge. However, contempt findings may still be imposed against the CFTC for its conduct in connection with the prior settlement, although the defendants may no longer be requesting such an outcome. Pitchers and catchers arrived in Florida and Arizona last week, signaling that Major League Baseball season and spring are not far away. So I began psyching myself up for the imminent change in seasons. Let's get started. IOSCO issued a comprehensive report last week enumerating issues and risks associated with crypto asset trading platforms, again, CTPs, and considerations regulators may apply in evaluating CTPs within their regulatory perimeter. Generally, IOSCO's considerations addressed access to CTPs, protecting customer assets, identifying and managing conflicts of interest, transparency of CTPs' operations, market integrity, including rules governing trading and how compliance with such rules are monitored and enforced, effectiveness of price discovery, and ensuring the resilience and cybersecurity of technology. For purposes of its report, IOSCO defined a CTP as, quote, a facility or system that brings together buyers and sellers of crypto assets for the purpose of completing transactions or trades, while a crypto asset, end of quote, while a crypto asset is a type of, quote, private asset that depends primarily on cryptography and distributed ledger or similar technology as part of its perceived or inherent value, end of quote, and could represent an asset or ownership of an asset, including a currency, commodity, security, or a derivative on a security or a commodity. IOSCO noted that CTPs are in many respects similar to trading venues, but may also perform functions typically undertaken by intermediaries, custodians, transfer agents, and/or clearinghouses. In articulating considerations, IOSCO made clear it was not mandating a specific regulatory outcome. Rather, it was articulating, quote, specific areas that IOSCO believes jurisdictions could consider in the context of the regulation of CTPs, end of quote. IOSCO's stated considerations are thoughtful and worth reviewing. Check out more details regarding these on the article version of Bridging the Week at www.bridgingtheweek.com, as well as my view on the likely submission by the Commodity Futures Trading Commission to the federal court hearing the Securities and Exchange Commission's enforcement action against Telegraph Group, Inc. and TON Issuer, Inc. The presiding judge in that matter requested the CFTC to weigh in with its views. Ultimately, I don't think the CFTC will be helpful, but I hope to be surprised. Kraft Foods Group, Inc. and Mondelez Global, LLC, apparently agreed for a second time to terms of a settlement with the Division of Enforcement of the Commodity Futures Trading Commission arising from the CFTC's 2015 enforcement action charging the two companies with manipulating and attempting to manipulate December 2011 wheat futures contracts and cash wheat. No terms of the settlement were announced, but in a docket entry made by the Honorable Robert Blakey on February 14th, the presiding judge stayed all pending court proceedings and referenced, quote, ongoing settlement negotiations, end of quote. The Honorable Judge Blakey also partly granted defendants' August 16, 2019 motion for contempt, sanctions, and other relief against the CFTC, and indicated he will issue findings of fact and conclusions of law by separate order, even though defendants will apparently withdraw their request for such an outcome as part of the revised settlement. In August 2019, the defendants agreed to remit $16 million to the CFTC to resolve the original enforcement action. The consent order reflecting the settlement, unlike other typical CFTC consent orders, did not contain any factual findings or conclusions of law. In their settlement, the CFTC and the defendants agreed not to make any public statements about the case other than referencing the settlement agreement between the parties and public documents filed in the enforcement action. However, concurrently with its announcement of the settlement, the CFTC issued a press release summarizing its complaint against the defendants, including a statement that, quote, the $16 million penalty is approximately 3 times defendants' alleged gain, end of quote, and a comment by Chairman Heath Tarbert regarding the harm of market manipulation to farmers. The CFTC also released a statement of the Commission and a joint statement by Commissioners Dan Berkovitz and Ralston Benham. After a tortuous motion practice journey that included a stop at the Court of Appeals for the 7th Circuit and threat of criminal contempt against the CFTC, the Honorable Judge Blakey formally set aside the settlement on October 23, 2019. The parties have resumed motion and discovery practice related to this matter since then. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. You know what I'm going to do now. Say check it out. I'm Gary DeWaal. Have a nice week. Until the next edition of Bridging the Week. Ciao.